Abusiamamu Aqua be Emerald Channel, so IGH Politics Avenue. Political structure training because make headlines. Nigeria need to be Akroma. Our need to be Braximo. Mr. say Yambo in Ryan Simo. And then upon ye coing Sima, not a year remove Chief Justice Member-Torkornoo. Now Manoka say Intel Yagada IDB Akroma and say Mami in set a good in Sayama. And yasam kuchwa chopa nende wapebia na mfano asa ndi record na hwese court ya bwana na nyina se ne siko bobo wiema there's one sign back to begging but at this point in time Intel yagada extract mami ohu abeg se ebeya enka omampan emana kunya no nanka on tra bench no so as a Supreme Court judge as an ordinary member omampan be pray. And now say who is thinking otherwise. Mama, your comment under the comment section.
5, purporting to remove her, in this case, she the applicant, hearing from both the office of the Chief Justice and the office of a Justice of the Superior Court of Judicature is unlawful, null, void, and of no effect. Essentially that this warrant of her removal executed by the president cannot have the extension of its powers to cover the removal of a justice of a superior court of judicature. Because bear in mind, the Chief Justice served 2 roles. And even prior to her removal, this conversation about if she is removed, can she still serve as a justice of the Supreme Court is one that was rife. This warrant of her removal, as was issued or executed by the president, brought that matter to rest. And this is what she's challenging, essentially. We'll put it on the screen. This is the warrant that she mentions in her relief. Now, therefore, know ye all men, that I, John Dramani Mahama, President of the Republic of Ghana, in pursuance of the said Article 1469, do hereby remove the said Chief Justice, Justice Gertrude Araba Isabasaki Tukono, from the office of Chief Justice and Justice of the Supreme Court. So this warrant, the powers of it applied to the 2 offices that she held, with immediate effect, in witness whereof I have hereunto set my hand and caused the presidential seal to be affixed at Accra this 1st September 2025. Akuffo Bento. Now, start off with you on this. I mean, look at the demands that have been made in this relief, and I'm mindful of the limitations that we have in discussing this matter. But references have been made to past cases and the fact that aspects of the relief being sought for has already been dealt with. Does this position or the argument being espoused have the potency to alter the power of this warrant of the president, removing her as Chief Justice and also a Justice of the Supreme Court?
Right. So when you say whether something has the power to alter something, you know, we are in deep law here. And let me just...
The law is the law.
Oh yeah, the law is the law, but honestly, it is not that obvious all the time. Yeah. So
let me, forgive me, let me acknowledge the presence of Christian Mamhesi. He's a private legal practitioner as well. This is the table of lawyers this morning. Council, good morning.
Now, at least you have a genius, right?
Yes. At least now I feel that I'm now beginning to feel, you know.
Thank you. So, thank you. Welcome. Yeah. Great. Incidental.
Right. So, lawyers will say there's something which is void, ab initio, and then there's something which is voidable. So, President has done something. The lawyers will tell you, if you do something, or again, they will say you can't put something on nothing. If you do something which you don't have the authority to do, it is void ab initio. It never had power. And sometimes, given who you are as a terror, and even sometimes based on ignorance of the people it affects, people don't know that it's void, they will carry it on until somebody realizes that it is void, and then they void it, so it's voidable. Now, question, therefore, is there anything here that can be said to be void or voidable? That brings another thing into, sharp relief. And we need to understand this fundamental principle. I've been saying it all week, that in a constitutional republic, nothing is final until the justices of the land make a pronouncement on it. Unless the person decides not to take it up for judicial pronouncement or the statute of limitation runs. So you can elect a president, and the justices of the Supreme Court can sit and say that election was void. So nothing is final. That's point number 2. Void or voidable, and the finality unless there's a judicial pronouncement. Then the question is there a cause? All right? We say any fool can go to court. But the question is, will you win? Is there a cause? Is there any leg upon which somebody or something can stand? And to this extent, please, we all, first lawyers, and second the rest of the nation, have to appreciate that look. If there is room for us to expand the frontiers of law, justice, and freedom, we should never foreclose on those things. Let the process be gone through. Let every facility be exhausted, and then we can proceed. Why? There's a difference between a legal constitutional process and a political process. And we've been making the mistake in this Fourth Republic of making legal constitutional processes political processes. To the extent that when we embark on those things, the last time I was here, I call it railroading. You put the person on the railroad, the rail will determine where they will end, regardless of what the law says. It's wrong. And I'm telling you, when you have a situation where legal processes are made into political processes, you go straight to become a banana republic. It's happening in other countries now where the justices don't have any say. The president says something and then they just come and rubber stamp it. We lawyers know the case of Marbury and Madison. And why that is important for the rest of the public is this. When some people in their power do something, even where they believe it is right, okay, in another case where there was the Marbury and Madison situation, the justices of the Supreme Court sat down and went beyond what those people had done, stopped it, and did what was right. And therefore seized power to determine finally how things may be done. I'm saying all these things because I hear people talk about, oh, Madam Torkornoo, why is she still struggling? Why does she want to come back? Why is she's disgracing herself? And I got into trouble when I said that some of these emotive, okay, suggestions and unsolicited advice and all those things, they don't help expand the frontiers of law. So let me come to the substantive issue now. It is in the Constitution that there's a separate process for appointing a justice of the Supreme Court. And there's a separate process for appointing the Chief Justice, who is the Supreme Justice of the Supreme Court. 2, there is a separate process for removing the Chief Justice. And there's a separate process for removing a justice of the Supreme Court. One is CJ, one is JSC. Okay, and so on and so forth. There's a reason why these things are there.
The oath taking.
Yes, the oath, you go for a different, parliament, everything. Look, it is not for nothing. Okay, now, and there is a lacuna. There is a situation where that determination has not been emphatically made. My brother here, Martin, and I don't have to tell you I respect Martin. He's my lawyer and I'm his lawyer. But when we disagree, it's on principle. Earlier on we were on radio and afterwards we were still discussing the matter. This whole week.
We discussed it.
We keep talking. But the point is that he sent me something which was extremely persuasive. I read it and then later I read. Then I realized that that section that he sent me, which said those things, were orbital. And again, I said we are in hard law, so please permit us. It wasn't a ratio. So when you have a case in court, there is what is called a ratio decidendi. The main reasons why the decision is made the way it is made. And then after that main decision, there are other things that are said around the issue. What causes or creates a precedence which is binding on other courts is the ratio decidendi. It's the ratio. However, the orbiter has persuasive effect, but it is not precedent creating. So I pointed out to my brother Martin that, look, somebody in the ratio had said that, oh, if you remove Chief Justice, then hey, you have removed this one. Okay?
Yes.
Yeah.
Because he referenced decided cases, on this particular matter.
That is why I'm going through ratio and this thing.
Yes.
That you see, that case, somebody made a passing remark. And it's arbiter. Arbiter does not create precedence. Let me explain to you why. When a case is before the court, the justices go into the merits of that case. They don't examine other things as much as they examine what is called the issues. So in ratio, the issues are dealt with. But arbiter, it is said in passing. And many times, arbiter makes sense. Because they say, hey, if they remove your Chief Justice, then they've removed, they have this. So. And the person was trying to say that, look, it is a serious matter, so please, be careful how you deal with it. Because once the person is removed as this, it could mean that they are removed as this. And let me also make the last point before I go into another matter. When they say somebody may do something, or an action may lead to something, in law, it also means that action may not lead to that thing. May swings both ways. Okay, we have to do all these things now because we need to understand that when you have these kinds of situations where they are not clear, let the law be gone through. Justice Torkornoo is saying something simple. He's saying...
Are you going to the next point? Because
I'm going to the next point.
If
I'm going to the Constitution
would you
itself.
Describe Justice Amadou Tanko's...
Let me finish this point, please. I beg you.
In this particular issue, because then...
I beg you, I can't think about that now.
Yes,
let me finish this point. Only this point.
Yes.
There is a separate process for removing a superior court judge. The composition of the committee that removes a superior court judge is different from the composition that removes a Supreme Court judge. So the point is being made that even though we have all been thinking that, oh, this knocks out this, one bullet kills two things, one stone kills two birds, it is not so. And the framers of the Constitution did not design it as such. So please, at the least, if a reason takes out the Supreme Court justice, okay, which comes through a separate committee, Constitution Committee, that reason cannot take out the Chief Justice, clearly, because a different committee has to be set to deal with that. In the same way, if that different committee sets, and if you permit me, I'll read it, it's in 146, a different committee set to remove the Chief Justice, a different committee has to be set. And if they like, they can take those same reasons and go through that process also to remove the person as a justice of the Supreme Court. There is a case there. There is a point there.
Okay, so 1464 is what you referenced. I'm going to put that on the screen right now. So are you saying that in this Frank Ejetum case, which has actually been the reference point for this entire process and why the Chief Justice cannot serve as a justice of the Superior Court after being removed as Chief Justice is an arbiter in meaning?
Yes.
And so does not necessarily apply in whole?
Yes.
That in the reasoning of Justice Amadou Tanko, that, quote, I have arrived at the conclusion that this application must fail without relish, mindful of the fact that the applicant, the Honorable Lady Chief Justice of the Republic, is going through a process that may define her career on the bench as Chief Justice and as a judge of the Supreme Court or the Superior Court. Then there is also this Ejetum case as well, where Dateba also gave what you would call the lead opinion of the Supreme Court, and Justice Sophia Akuffo actually concurred in that regard. And you're saying all of this are arbiter and cannot apply in whole?
So my colleagues here will tell you that, yes, Justice Tanko's statement was arbiter, and he said, we need to be careful when we are dealing with this, because it may define her career as a justice of the Supreme Court and maybe lead to the removal. And I've explained that when somebody says it may define her career, it is true that it will actually define her career. If you are moved from here to there, it puts a certain mark on you. But if you say it may also affect her as a justice of the Supreme Court, it also means it may not affect her as a justice of the Supreme Court. So we are being careful here. And the last time I said we need to be very sober about some of these things. If we don't like the Constitution as it is, do what Martin Kpebu did, or whoever. Go make a case and let's get an amendment. But we have a situation where the thing is written there, it has the force of law, it is what we are living our lives by, which is why I make the distinction between a political process and a legal process. If we go by the legal process, the law is the law. And we have to have fidelity to the law. You don't agree with it, amend it. But if it is what is there, do what the law says. And the law says you can't remove a justice of the Supreme Court unless by a certain specific process. And to that extent, look, there are many other things, okay, which this occasion may give rise for us to look at them again and go deeper into them. For instance, this whole issue about prima facie, which Ejejum dealt with, okay, I have read and I have here the testimony of Nana Dr. S.K.B. Asante. And he has made it emphatically clear that that prima facie requirement is so fundamental and so crucial that if it is not respected, the whole process is null and void. He used the term, it is fatal to the process. These are serious. And it's not me. This is Nana Susubibi, KB Asante. All right? Gentlemen, we are trying to
say.
I can give it to you if you want. But
In the report of the committee of experts for the Constitution.
This is his witness statement. Okay.
Okay.
And it's here.
Okay.
Okay. And I'm saying, don't take my word. Nation building is a slow, but has to be a deliberate process.
Okay.
And you know about ad hominem approaches. You look at somebody, you like or don't like the person, so you approach in a certain way. And I'm saying a political process by Edwiji and Co. And Edwiji wears two hats. When he's doing his politics, different. When he's doing his law, different. Tomorrow, these same things will be applied somewhere. We missed an opportunity in Charlotte's case. If we had been more careful and gone about it the way I am suggesting now, a bit more deliberate and stop looking at the politics and the politicians of that time who railroaded Charlotte, okay, we may have arrived at a different conclusion here and may have been a bit more careful. So, if you say Nana Susubibi says, Dr. S.K.B. Asante says that the original process was fatal. What it means, it was void ab initio.
On what grounds?
On the grounds that the prima facie requirements were not gone into. So, you know, because of time. Yeah.
But the Supreme Court says, the Supreme Court says failure to give reasons for a prima facie doesn't make the case void. That's Chachu Chikete's case.
Okay.
Over 20 years ago, 2003, 2004 Supreme Court. Chachu Chikete went to the Supreme Court that the failure of the trial to give reasons for saying that there's a prima facie case, so he should open his defense, makes the case void. The Supreme Court said, no. It just
but
means
that's too far. Republic versus Michael Asamoah.
Are we talking about the removal of a chief justice?
No, I'm just talking about the prima facie, criminal, liberty.
Yes.
Hold on.
Let me make my point. See, so, let the justices who are more experienced than us and have the actual office to do this, take these matters, go in chambers, deliberate, and then come and tell us finally how we proceed on this. Because if Nana Susubibi says that absent a prima facie determination of the Council of State, wait, let me finish.
Yes,
Because you see, when you say something is present but it is only with you, it must be give the person the thing. No, wait. Was she given that?
That's the reason. She was giving communication that there is prima facie, no explanation.
So, you see, what we are doing is why this matter should go to the justices. Yeah, you're not getting me. My point is, we can't agree on this. And I'm saying, a very serious person is saying, not doing that is fatal.
No,
So I'm simply saying
said otherwise.
I'm
so
saying
it's not what SKB Asante says.
well, you are not hearing my point is the fact that we disagree is the reason why it must go before the
agreement. The law has been clear that if you fail to give reasons, it just shows you are biased, you are thoughtless, there's malice.
Okay, so
that's what the Supreme Court said. So you can make those allegations.
Dr. SKB Asante says that it is this. And I'm saying you are clear in your mind it is not so. Unfortunately, this is not a Supreme Court bench.
The Supreme Court has pronounced twice on failure to give.
Mr. what would be the implication of the removed Chief Justice still sitting on the bench as a justice of the Superior Court because of what led to her removal? That is stated misbehavior. She's been removed as Chief Justice, then she's still sitting on the bench as a Superior Court judge.
I don't understand what you mean by what would be the implication. The person has been a judge for over 20 years, risen to the topmost office.
21 years.
Yeah.
To the
topmost office. Okay. Now, she is elevated to perform additional administrative duties. Has nothing to do with her competence and experience as a judge. In other words, she is not in any way incapacitated from performing her duties as a judge. Now, during the performance of her administrative duties, the persons in charge of accounting, the heads of finance and whatever it is, approved for her to do something which previous chief justices had been doing. And she did it.
But that doesn't make it right.
Let me answer the question, please. I'm not saying it's right or wrong. I'm simply saying that something like this happens. The only institution in this country which is legally mandated in our constitution, the Auditor General's Department, audited that action, raised questions, and the questions were answered. In their final report, they took that issue out and published the final report that this is not an issue. In previous situations where it has happened, it never was an issue. In other situations where similar things have happened, the highest punishment was a refund. And it was not something that goes to the heart of the performance of her duties as a judge. And the matter had been rested. Then a committee which does not have the same level of authority and expertise as the whole Auditor General's Department resurrects the settled matter, uses
we and some who to cause watch on some mamma so jemre or had a sentence or body in the Dumbi Adominia and some realm, Diane Sumo Consul. How age politics are